Hello students, this lecture is entitled Influences the Federal Agenda on the Legal System. So when we're thinking about the legal system as formed by the Constitution, there's a couple things we have to think about. So prior to the Constitution, under the original colonial governments, each state had its own supreme judicial authority. In many cases it was very similar to like a Supreme Court type body. And each of these states dictated their own laws, and from those Supreme Court decisions, that was the final say in each state. Now, under a national government, under the Constitution, now the big change, written under the third article of the Constitution, is a call for a Supreme Court. And this concept of a Supreme Court is somewhat vague in the Constitution. So in the Constitution, the Supreme Court is created as sort of this arbitrator, this extra governmental body. It's not elected, it's appointed by the president, but then the appointments have to be sanctioned by the Senate. It's a life appointment. So this type of position supersedes politics, is not aligned necessarily to one party, and does not necessarily have to follow what the president or the Congress wants them to. This is the intention, perhaps, of the Supreme Court. But in terms of how the Supreme Court is actually organized and what true powers they have, there's not a direct delineation of that in the Constitution, such as the President and the Congress, where there are several statements that Congress shall have the power to, the President shall do this. The Supreme Court is really left in this sort of nether region. So in the early Supreme Court, there really isn't an understanding of what the Supreme Court's role really is. I mean, when John Jay becomes our first Supreme Court justice, there are really not a lot of cases that go before the Supreme Court because the Supreme Court doesn't know if it even has the authority to listen to cases. Now, as we get past George Washington's presidency and we enter into John Adams' presidency, we start to see the Federalists taking front and center in our government. And the Federalists were that party, that very conservative, traditionalist party, very much the supporters of the British. Not necessarily the British government, but the British way of life, the democracy that of upright citizens, of properness, of high class, of good government, of education. And the Federalists do believe that educated upper class people should be in power, just like the nobles and the upper class were in power in England, and that average people don't really know how to participate in government. They have other roles. They're farmers and sailors, and government really is not their forte because they don't understand how government really needs to work. So the Federalists end up taking power initially. Alexander Hamilton stands out as really the leader of the party. John Adams is the presumptive president, seeing that he has been instrumental in creating our nation, of developing the Declaration of Independence, of fighting for money in Europe during the Revolutionary War, of getting grants from both France and from the Netherlands. John Adams is not well liked as a president. You know, he has this air about him, does not believe that the presidency should be able to be criticized, and supports these alien and sedition acts, which really make him more of a paranoid, in the sense that average people are not allowed to speak out against him under these acts. And the Democratic Republicans, the party of Thomas Jefferson, they start to demand more average people having a say in government, of less of this conservative British style of governments where you have more democracy and less elitism. So by the time you get to the end of Adams' presidency, he doesn't really have the support to win a second term. And he's running against his vice president, Thomas Jefferson, who happens to be the leader of the opposition party. And from 1801 until about 1823, 24, you're basically going to have this dictatorship of Democratic Republicans in power. They're going to control the presidencies of Thomas Jefferson, followed by Madison, followed by Monroe. And they're going to eventually control Congress, because during the time of the later 1812, 1813, the War of 1812 period, the Federalists are going to stand up and they're going to be against the war. And they're even going to have a Hartford Convention saying that they're so against the war that they're willing to meet in secret in order to try to form a confederation separate from the United States. So after the victory in the War of 1812, the Democratic Republicans really, they gained power. And from about 1814 until about 1823, you have this era of good feelings. You have the rise of James Madison, and then you have James Monroe, and a lot of positive things are happening, not a lot of political turmoil, and there's relative ease and calm. And the Federalists, well, they sort of fall out of favor and they lose their status as a national party. And for a long time, we really only have one party, the Democratic Republicans. And obviously, there's going to be factions in that party. But really, the Democratic Republicans stand alone, and the Federalists can't really compete in national elections. Now, the one thing that Adams does do that changes the course of history, though, is before he leaves the presidency, he appoints his Secretary of State, John Marshall, who was a fervent Federalist, to the role of Supreme Court Chief Justice. And being on the Supreme Court, again, you have the power to stay on there for the rest of your life. So John Marshall, his impact is not only going to affect this short period of time when Adams appointed him, but he's going to be Supreme Court Justice through Jefferson, through Madison, through Monroe, even into Quincy Adams. So John Marshall, being a fervent Federalist, he goes in with a different perspective on the Supreme Court. Coming from the Federalist perspective, he believes the Supreme Court needs to assert itself as the superior court to everything else, and that the federal government needs to assert itself as the actual powerhouse of America. That state governments, yes, they have some things they can decide, such as marriage and education. But in reality, when it comes to major decisions, foreign policy, commerce, the federal government has the final say. And if the federal courts, in this case, which are very small, we have the Judiciary Act, which establishes federal courts. Not a lot of federal laws, though. And federal laws are not necessarily followed as people are traditionally following state laws. So in 1801, when John Marshall comes into power, he starts to do things in the Supreme Court that will forever change our legal system and will forever establish a system in which the Supreme Court's main role is judicial review. So one of the first cases that John Marshall is known for is this case Marbury versus Madison. And in Marbury versus Madison, there was a government officer, Marbury, who was appointed by Adams, and Madison would not really accept his appointment into government. Madison at that point was the Secretary of State under Jefferson. And there was this big hullabaloo about, well, shouldn't the president, at this point Jefferson, shouldn't the president have to be forced? Shouldn't his hand be forced that he has to accept Marbury as a government employee because Adams appointed him, and according to the law, you need to accept political appointments in a certain order. And this went to the Supreme Court. So it was brought forth by Marbury to the Supreme Court, and in Marbury versus Madison, the Supreme Court, under John Marshall, decided no, the Supreme Court really can't tell the president what he has to do. Can't really force the hand of Secretary of State Madison. But in doing so, he made the decision, with the rest of the Supreme Court justices, the 5 of them at the time, that the Supreme Court does not have absolute authority, but does have this power of judicial review. And judicial review means that if lower courts make decisions, and then it's appealed to the Supreme Court, ultimately, the Supreme Court can interpret the Constitution. And if the Constitution itself goes against something that a state made as a law, or even as something as the federal government made as a law, the Supreme Court reigns supreme. So judicial review, which was not included in the Constitution, is going to come out of Marbury versus Madison in 1803. So this whole concept of an activist court is going to be an influence from John Marshall. And over time, you're going to start to see people that are serving in the Supreme Court who may not be Federalist, but they are open to judicial review, which is something that Jefferson is not a fan of. He believes that the Constitution has to be interpreted by states, and if the states believe that something is fair, why should the Supreme Court have to overturn a state law? Now we get into this whole concept of federalism. So the Federalists believe that the United States is more powerful than the states, and that's how it's always been. It's the supremacy clause of the Constitution, that the federal government has the final say. Whereas Democratic Republicans still believe that it's a balance between state and federal, and that there's certain things the state should be able to authorize and certain things that the federal government should be able to authorize. So what we get is several cases over the next maybe 15 years that are led by John Marshall with the help of his other members of the court, such as Thomas Todd, Gabriel Duval, Bushrod Washington, the nephew of George Washington, Henry Livingston from New York, and even Democratic Republican William Johnson, who, although doesn't support necessarily Federalist agenda, does believe strongly in judicial review, that the Supreme Court is the ultimate authority. So over the next 15 years, there's other cases that strengthen the power of the federal government. The first case is a case called Martin versus Hunters-Lessee, and that takes place in 1816. And in this case, there is a question that should states have the right to make laws that the federal government cannot have power over? Now, Marbury versus Madison, before I confuse you, said nothing about whether states have more power than the federal government. It simply stated judicial review. This case, Martin versus Hunters-Lessee, is going to be the case that establishes that the United States government, and the United States Supreme Court, as an extension, has the authority over lesser courts. So in fact, this weakens states' rights. And the states' rights fighters, the eventual Democrats, who will be the Confederates in the Revolution, in the Civil War, the ones fighting for states' rights. This is where these arguments are going to start, way back in 1816. And then in 1819, you have McCulloch versus Maryland. And in this case, you have the argument that should states be able to undo laws that go in contradiction to what the Congress wants. And in this case, John Marshall and the Supreme Court justices rule also that states are not allowed to make laws that contradict constitutional laws supported by the Congress. So if Congress makes a law supported by the Constitution, state can't undo that law. So these are some of the Supreme Court cases that John Marshall is going to sponsor and write the ultimate decision on these cases. But what's going to end up happening is you're going to have a lot of political influence on these cases. Because each of these cases really call into question, how powerful is the federal government? And should the federal government be as powerful as the states, or more powerful, or equal? And time again, in this time when you have Democratic Republican presidents and Democratic Republican Congresses, you still have the authority that the Supreme Court is deciding that states should be weaker, the federal government should be stronger, states should not have the power to make laws that contradict the United States laws, which we still hold true to this day based on these cases, and that the United States Congress should have a power and an authority to make laws that affect all. You even have the case of Gibbons versus Ogden, which calls into question this Commerce Clause, which has come up in recent argument about the Obamacare, the Affordable Care Act. Does the United States have the power to regulate commerce? And in this case, that was the argument made of why the Affordable Care Act was legal, because it was based on the Commerce Clause and that it was a tax that the government could authorize and force people to pay and to buy this insurance. But getting back to Gibbons versus Ogden, in this case, the United States the Supreme Court confirmed the United States has authority over most commerce, most interaction of business between states, between the foreign powers in the states, and that individual states cannot have their own laws that go against another state's laws if it's interstate commerce, things passing from one state to another. Again, weakening the power of the state government, enhancing the power of the federal government. Now, John Marshall is going to continue to be Supreme Court Justice from 1801 into 1835. And in those 34 years as Supreme Court Justice, he is going to impact our way of dealing with law in this country and the power of the government and the position of the Congress. And ultimately, even though there is not an elected president that's a Federalist, and even though the Congress is still dominated for the most part by these Democratic Republicans who eventually become Democrats, the legacy of John Marshall will forever be emblazoned into our government and into our way of life. To this day, the Supreme Court still has the power of judicial review based on Marbury versus Madison, still has rights over states based on cases like Martins versus Hunters-Lessee and McCulloch versus Maryland. And the argument shall always be, when the federal government makes laws, do states have to accept them? And in this case, the Marshall Court said yes. And this is going to lead to issues like the nullification crisis of 1832 in South Carolina, where there's a tax that's made that's going to be paid by all citizens of the United States. South Carolina calls this the tariff of abominations and refuses to pay it. And in doing so, goes against what the Supreme Court has decided, that the federal government's laws go for every state, no matter if states agree with them or not. So this shall be the ultimate impact of John Marshall's Supreme Court Chief Justiceship, that the United States shall be supreme here and forever.